So firstly, I just want to highlight the fact that for those in the CIC that we do have a dedicated second tier support service for the staff and volunteers of the various centres throughout the country, and that's actually been in operation now since 2012, and that service operates Monday to Friday between 10 and 4. Primarily, it can be contacted through the number there, the 1890 299 499. And that number actually is going to be changed in the coming months as we're moving away from the 1890 number. So that'll be changed to a free phone number, 1800 299 499. But we'll circulate information in advance in relation to that. The service can also be contacted by email through cicadvice@threshold.ie. And in terms of our services, as we continue to operate remotely, we're looking at providing online consultations via platforms like this for our clients, but it may also be something that may be of interest to the staff and volunteers of the CICs as well, in being able to access the service. So as I mentioned, my colleague Owen is looking after that service in the main. So some of you may have been in contact with him already. Threshold is a housing charity, and we were set up in 1978. And our aim, I suppose, is to resolve housing problems and to prevent homelessness. And we do this in a number of ways, one of which is in relation to our advice and advocacy services. It's a national organisation. We have 3 offices, one in Dublin, one in Cork, and one in Galway. And the services are primarily accessed through our free phone helpline, which you can see there, and that's operational Monday to Friday from 9 until 9. And increasingly, as we've been operating remotely, we're getting a significant number of queries via our website, threshold.ie. And last year, we introduced a web chat functionality to that, and that's proven to be extremely popular. And as I mentioned, we will be in the near future rolling out online consultations as well. Certainly, the service has been impacted in relation to COVID-19, and that's primarily because for the past year we haven't been able to meet with our clients face to face, and that's often necessary for a lot of our clients, particularly vulnerable clients and clients with, I suppose, literacy issues, language issues, etc. Meeting face to face, there's no substitute for that, and but unfortunately, the service has been curtailed for the past year, and we can't have face-to-face meetings, and that also has impacted on the likes of our outreach services. We have a number of outreach services. We'd twice weekly be in the offices of Dublin City Council in Wood Quay, and once a week we'd be in the homeless services in Parkgate Hall. And then we'd have a twice weekly outreach service in the offices of Fingal County Council in Blanchardstown. And then also for the CIC attendees here, we have an outreach in the Balbriggan CIC service as well. But unfortunately, as I said, for the past year, we haven't been able to operate those. So our aim, I suppose, is to give people the information and the advice that they need to be able to resolve problems themselves where possible. And in many cases, that is all that is needed. But in some cases, clients need further assistance, and that may be informal advocacy. So that could be, for example, contacting an agent on behalf of a client to try and get a repair done, or writing to a landlord in relation to an invalid notice that they've given the tenant. And again, that could be quite successful. And then in some cases, we may be required to provide formal representation for our clients, and formal representation would primarily be before bodies such as the Residential Tenancies Board and also the Workplace Relations Commission in relation to discrimination in accessing private rented accommodation. Primarily that would be, for example, where people are facing discrimination in relation to applications for HAP support with their housing need, for example. So both of those have continued over the past year, albeit again operating remotely in the main, but hearings do continue to take place with both the RTB and the WRC. So we're just going to spend a few minutes looking at the private rented sector in general, just trying to put it all into context. So these are based on the RTB end of year stats. You can see there that there were over 297,000 tenancies that were registered with the RTB at the end of last year, and that was down slightly in terms of the number of tenancies that were registered. At the beginning of the year, it was down 1.5%, and likewise the number of landlords who have tenancies registered with the RTB, that was down around 2% throughout the year. So that would obviously indicate that there's been a decrease in the availability of private rented accommodation. That has been happening anyway prior to COVID, but it is continuing to happen as a number of landlords are or do seem to be leaving the market, and fewer and fewer properties being available for people to rent. In terms of the tenancies registered with the RTB, obviously where a new tenancy is created, that's required to be registered with the RTB, but also where a tenancy cycle is renewed, the details also have to be registered with the RTB. The vast majority of tenancies registered were in the last quarter, they were new tenancies being created, and in Dublin, quite significantly, over 70% of the tenancies registered with the RTB were actually for tenancies within apartments. So these two charts just represent the decline in terms of the number of tenancies that are registered with the RTB throughout last year, and then also the number of landlords. And the vast majority of landlords in Ireland are landlords with 3 or less properties. I think last figure was over 70% of the landlords in Ireland would have 3 or fewer properties. And many of those would be landlords, for want of a better description, would be accidental landlords, perhaps people who it's not their main occupation, and it's probably something that they got into either as an investment for a pension, or perhaps they inherited a property and are keeping that property by renting it out. So this next slide, this is based on the registration details that were there for Q3 in 2020. Unfortunately, the RTB have ruined my presentation because just this morning they released their Q4 stats. So I haven't had time to update all the slides yet in relation to that, but there hasn't been too much of a change. So just looking at the tenancies registered with the RTB, you can see there that over 45% are tenancies within the Dublin area. And then outside of that, GDA, that's the Greater Dublin area, so the commuter counties, Wicklow, Kildare, and Meath, and then you have the rest of the country. So it's pretty much an even split between Dublin and outside of Dublin. And what's interesting, I suppose, is the types of properties that are registered with the RTB. So you can see overwhelmingly the main type of property rented out is apartment dwellings at over 71%. And then you can also see then in terms of the number of bedrooms within the properties registered with the RTB that the majority are either 1 or 2 bed properties, and that would, I suppose, reflect the need and also the change in demographics in terms of household compositions, as we are seeing smaller and smaller households, and therefore that's where demand for the accommodation is at its highest. So every year we undertake a tenant sentiment survey, and we're currently in the process of doing the 2021 survey, but I thought it's useful also just to highlight some of the key findings from the survey that was carried out last year. Last year was quite interesting because the survey commenced at the beginning of the COVID measures and was paused until later in the year. And so we had a follow-up then in July, but you can see some of the key stats there from the tenant sentiment survey, that the largest category of household contacting us were single, 41%, and 64% were aged over 35, and almost a third of those surveyed at the time had been impacted as a result of COVID-19. And I suppose that looking at the bottom there, you can see that 41% were in receipt of a welfare payment, and almost half of those surveyed said that they were renting because they couldn't afford to buy. And then more worryingly, 91% stated that they had found it difficult to source accommodation. Also, over half of those surveyed indicated that they were spending more than 30% of their take-home pay on their rent, which obviously has huge implications in terms of affordability. And just under 40% felt secure in their private rented accommodation. So as I said, that this is a survey from last year, and we're currently undertaking a survey this year, and that'll be primarily focused on the impact of COVID-19 in renting. So it'll be interesting to see the results of that in the coming months, and we'll be able to share that with you. Does anyone have any questions before we move on?
I just thought it was striking there that 39% felt secure in their tenancy. I mean, that means about 60% don't feel secure in their tenancy.
Absolutely. I suppose, look, if you're looking at the private rental sector, what you're looking at is, despite all the legislative changes, is a lack of security, a lack of availability, and a lack of affordability. And those, you know, they appear to be constant, if not increasing. And that's certainly continues to be the case in relation to COVID-19. Even though we have the various protections, people still don't feel secure in their homes, because, as we'll see in a moment, you do have some security of tenure under the Residential Tenancies Act, your Part 4, further Part 4 tenancy cycles. But those tenancy cycles, whilst they can last for up to 6 years, those tenancy cycles can be ended. And they can be ended, you know, on a number of specific grounds. And if a valid notice is given, then you really don't have any defence to that, or any argument that you can put forward to that. So if you're a family living in a specific area and renting, and you have children going to school in the locality, and the landlord comes along and in normal circumstances gives you a notice of termination because they intend to sell that property, then there's very little you can do about it once that notice is valid. You know, basically your security is knowing that your tenancy can only be ended in a specific way, but you don't, for example, have much of a defense against a notice being served if it's valid, and you will then just have to comply with that. And then the difficulty is obviously trying to then source alternative accommodation, which is often very, very difficult, and it usually results in people having to uproot and move further away from when they're currently living, as they try to find somewhere that's more affordable. And there, you know, there's a lack of available accommodation out there at the moment anyway. And that's even more difficult than if you're in a situation, as you all are very much aware, where you're dependent on support with that rent. So if you need HAP or you need rent supplement, that's capped, and market rent is way beyond what's provided for through HAP or rent supplement. And unfortunately, whilst it's illegal, a lot of people experience discrimination in either accessing their accommodation or seeking support during their tenancy. So, you know, the 61% of people not feeling secure in their tenancy, it is, unfortunately, it is a very high figure, but it probably does reflect the sentiments of the majority of tenants renting out there.
Can I just ask, from Threshold's point of view, sorry, I'm from the Department of Social Protection, and from Threshold's point of view, do you see the difference between Ireland and, we'll say, other European countries where renting is seen as a long-term lifestyle choice, and there is more commercial landlords in the picture, whereas here you're taking into account, by and large, you know, families just deciding to either, you know, buy a property to rent for pension purposes or whatever.
Yeah.
And from Threshold's point of view, do you see any way to change that? Because there seems to have been some kind of resistance to commercial landlords coming in and providing residential, you know, long-term tenancies. It seems to have been quite an amount in the media, and that it, you know, so from my perspective, I would see it as, in an ideal scenario, you would have two specific areas. You would have the county councils that would provide long-term tenancies as they did in the past, and build accommodation, family homes, etc., apartments, whatever is required. But if that could be tied in with large corporation landlords coming in, that would in some way then take off that fear that landlords have, that if I rent this property out on any kind of a long-term basis, my tenants will have more of a claim, and, you know, it's seen more as a kind of a, that's my home kind of thing. Do you know what I mean? And not a business venture. So
you're 100% spot on. That is very much, as we said, like over 70% of landlords in Ireland are the individual landlord who, you know, they have 3 or less properties, and as you mentioned, you know, very often they, you know, were either advised to maybe invest in a property. This could be your pension or, you know, supplementary income for them, or they inherited the property excuse me, and are just renting it out, you know, while they maybe decide what they're going to be able to do with that, and they wouldn't classify themselves as professional landlords. Nevertheless, they are a landlord, they are operating a service, and with that comes the various responsibilities in relation to that. And there certainly is an argument or a discussion to be had in relation to the support given to that class of landlord anyway, to, you know, you know, what we need. We saw there is a decrease in the number of landlords and the number of tenancies registered with the RTB. So we need to look at why that's happening, why people are leaving the market, and perhaps looking at what incentives are there to attract people to provide good quality accommodation on a long-term basis to people. And I know there have been some attempts in the past in relation to things like mortgage interest relief, etc., being given, where they took on tenants on a long-term basis if they're in receipt of HAP or rent supplement, but much more is needed to be done with that. I think in terms of the commercial landlords and bringing those in, yes, we're certainly way behind the much more established rental markets, particularly in mainland Europe, where, you know, you have this very strong tradition of renting as opposed to home ownership, and much of that is provided by long-term investment funds, pension funds, etc. So they tend to be very much more interested in the long-term picture and having that gradual profit being made. I suppose the concern in more recent times, particularly here, and particularly in relation to the likes of the vulture funds, etc., is that you have these commercial entities that are swooping in and profiteering on the market, and, you know, and that a lot of vulnerable people are being left behind, because in some cases, a lot of these providers, for example, the rents, they are going to be significantly higher than the supports that the DASP, for example, can provide to them. So there's fear that people are being squeezed out of the rental market as a result of these coming in. But there's probably, look, it's probably growing pains in terms of our rental sector, that it's effectively doubled in a very short space of time, and, you know, that has to, you know, kind of settle down, become more mature. I think our rental sector, unfortunately, it's very volatile, whereas other markets aren't as volatile. So, you know, we've had we have these boom bust cycles in relation to the rental market, and what we really need to do is try and get some kind of level consistency in relation to it, and if we provide certainty to the tenant, that we provide certainty to the landlord. And that there is long-term, affordable and good quality accommodation provided for people.
Could I just say, sorry, on that, Stephen, just it's trust is huge factor in the whole, or the mistrust is in this commercial thing, because like, do we trust the government to actually carry through on really holding the commercial entities like, I'm not far from Devney Gardens here, there's other places. The will of the government, and many years would have been involved in the St. Michael's campaign. So it's not, people kind of don't trust the commercials, because even NAMA have supported the vulture funds coming in and doing some business, like, so we don't feel like there's a will at government level to remotely look after the interests of people who are desperate for housing. But I hear Etna, I'm sure what Etna's saying is that they need to be bloody on the case, and have that way it could suddenly be an expansion, and a carefully managed expansion.
Yeah, absolutely. And it can be done, as Etna said there, that, like, there are examples where it is done in Europe in particular. And it's just we're way behind in that respect. And we just need to be very careful in how that's managed. And certainly we shouldn't be, facilitating the likes of vulture funds coming in and whipping up, these properties. But that, these should be provided, with the long-term aim is that we're providing homes for the most vulnerable.
From our experience in citizens information, when it comes to disputes being lodged with the RTB or notices of termination, that kind of thing, sometimes when it's a larger corporation that's the landlord, that there might be a better sense of professionalism there, that you only have somebody who's employed for a company who's managing to issue this notice to the tenant, and you can talk to them and they might be able to take it back if you point out that it's a wrong, that they've gotten the notice wrong or whatever. But I think in a bigger picture of things, there's problems there too, where you hear these stories of, there's a block of apartments where they rule that that tenants who are on HAP or on rent supplements, their kids can't use the playground, and all these atrocious stories that you hear coming out of the big commercial landlords. And I don't think there's a willingness there to rein them in and do anything on it. I think it's more just the case that they're treated the same as any other landlord. And at the end of the day, every landlord, whether they're commercial or individuals, they're going to want to maximize the rent that they take in. So it's a question of rent controls, irrespective of what type of landlord there is.
Yeah, it's getting that balance. And I think like in all walks of life, but particularly in housing, we have a tendency to box things. So things fit very neatly into a box. So you fit into this box where, Stephanie, you're saying, you get your family and you get housed by the council, and therefore you're then separate to perhaps this young professional couple that are starting out renting, but they can pay the rent themselves. So we have all these different boxes for people, and that you create silos. And I think what we need is much more of the mix that's provided. So again, going back to your point about mainland Europe, they have a much more sophisticated social mix, and you have people in all different stages of their lives, in all different socioeconomic circumstances, living side by side. Often, it's irrelevant that I'm working full-time and paying the rent myself. Next door is getting subsidized by their local authority, and for example. And I think that's what we need, more of a social mix to meet all of the various needs.
I think, Stephen, would it be fair to say that we really can't depend on the benevolence of a private company to supply our housing market with an adequate supply of the mix we need at an affordable level, that it has to come on a reliable tenure as well. So we have to go back to the state, and it can't be based on the goodwill of a private company. It has to be based in law, and it has to be based in regulation to say that these are the rights of the tenants. And I think this is where your talk today comes from, And so it's the lack of those rights. We can look to whatever area we want to, whether it's private or whatever. But if there's no controls, if there's no regulations, if there's soft touch regulations, which you've seen umpteen times in the past, they don't work. We need proper regulations to give people decent rental accommodation. And that's what a lot of European countries do. And we just won't bite the bullet and do that.
Yeah.
I think a lot of the issues, though, are historical. I think there is this mindset in the Irish psyche, going back to pre-famine times, whereby, everyone wants to own their own home, and I think that's ingrained in us as a society here in Ireland for historical reasons. I also think there's huge opposition, and I think while on paper, mixing people in housing units is a great idea. So you have somebody that purchases a house and has a mortgage, you have somebody else that's on a shared ownership scheme from a council, you have somebody else that's renting from the council or from a private landlord. In reality, from what I can see, and certainly I don't live in Dublin, I live down the country, but I have lived in Dublin years ago, it doesn't work in practice. There's an awful lot of resentment from people that are paying massive mortgages, and then the council come and buy a house and put a council tenant that might be on social welfare in there. And I know from where I currently reside, one of the owners in the development, and we're a very small little development, a great little community, but one of them decided to sell their property and did a behind the doors deal with the council without anyone knowing. And it was signed, sealed and delivered, and the council had purchased the property. And there was absolute murder among the residents there, who we had all paid massive mortgages for our homes. And while the council took our concerns on board and were very careful in the family that they put in there, that they would settle in and mix, there is still that very much they're renting and they're on social welfare, and we have these massive mortgages. And while they're a very nice family, that is still ingrained. I'm not saying by everyone, but there's a huge cohort that, that,
yeah,
I don't know what as a society we can do to actually break that, because
I think I think you're absolutely, look, I think you're absolutely right that they can, in these situations they don't always work, but there are reasons for it. And I think part of it is that silo, that it's an us and them, haves and have not. So if you either qualify for local authority housing or you don't, it's a very arbitrary cutoff point. Some people will meet it, some people won't. I think that's part of the fault. That's too harsh, and that people, almost everyone needs help at some stage in their life, and rather than having these arbitrary figures, that it's more adjustable depending on the individual's circumstances, because most people do need help at some stage in relation to meeting their housing need. And by removing those kind of silos, it will help. And look, the other side of the fence is in terms of where there is provision, social mix or attempted social mix. Unfortunately, the way it's been done is going back to, sorry, I didn't get the gentleman's name previously. Very often in new developments where, for example, they're providing the social and affordable element to it, it's not done in the true sense. It's very often it's done as a tag on at the end, or perhaps the social housing properties are tucked away from the other properties, or they're immediately, maybe the materials that are used aren't as good as the homeowners. They're just kind of thrown up in that, sure, they're going to the council, it doesn't really matter, so they're immediately different, and people can see that. So there isn't that social mix in the true sense. And then it does look, housing doesn't exist in isolation. The people live in the houses, so a lot of effort is needed then in terms of creating that community, and helping that community to grow and deal with any issues that arise.
I think just to say, sorry, I know you want to move on, Stephen. I think sensible people have a role to play in this process, in these processes as well. And you can have 10 people who have a problem with a new neighbor moving in, but all it takes is one sensible person to say, listen, have a bit of cop on. Nobody has a veto over who your neighbors are going to be. If the house went for sale, you don't get to decide who gets to buy the house. You don't get to decide who gets to move in and rent it either. And I think it's just a case that one sensible person to have that bit of cop on, to say, encourage other people to have a bit of cop on, is all it takes in these environments,
Yeah, but I suppose, yeah, summing up, going back to that, that's overall point, and that's what we need. We need, I suppose, at a government level to have that authority to, I say this, to have that cop on and to regulate the sector to, ensure that it isn't abused by bringing in, for example, the likes of the vulture funds. We certainly do need to interact institutional. We do need to professionalize the landlord in Ireland much more than it currently is, but that definitely requires oversight.
I can assure you that every time in the council we ask where the social housing pods in new builds will be, and we always ask that they are mixed with everything, and it's not.
It's never, it doesn't happen. And this is I suppose it goes back to that point. There isn't that, whilst there's the requirement that they provide the accommodation, there isn't that oversight, there isn't that accountability to ensure that the homes that are provided to meet the social and affordable need, that they're of equal quality to the other homes, and that they're properly mixed in with the other homes. Otherwise, it's not going to work. You're not you're not going to create your community. You're going to reinforce those stereotypes. You're going to reinforce the division between the communities. You're not creating proper social mix. So there has to be a body in terms of the provision. If it's the local authorities have to be able to have that power to go and say, this is the way this development is being provided. This is how it's being done. Go and do it. As opposed to generally what happens at the moment, the builder will come along and say, well, this is what we're doing, and there you go. But that's very, look, it's great. It's very interesting, and it's not that, look, we could talk about this for days and days, and it's it's very, very useful.
I have more to say, but I'm not going to.
I think we're all better off staying quiet now. We can only end up sound some rabbit hole or another.
These are the feelings that are out there.
Yeah, I know.
Yeah. Okay, so we're going to move on then. So the main part of today, we're looking at the private rental sector. And look, the private rental sector doesn't operate in isolation to any of the other sectors, home ownership, local authority, housing, etc. They're all intertwined, and what happens in one always has an impact on the other. So the Residential Tenancies Act, that commenced way back in 2004, and unfortunately I can remember a time prior to the Residential Tenancies Act in 2004, and there may be one or two people attended today that can perhaps recall prior to the Residential Tenancies Act. So as bad as we think it may be now, it was much worse pre-2004. At that stage, pre-2004, for example, if a landlord wanted to increase the rent, they only had to come along and say they were increasing the rent, and there was no cap on how much they could increase it by. And as a tenant, it was pretty much pay up or find somewhere else. If a landlord wanted you to leave, they only had to give you 4 weeks notice. You could be in that property a year, you could be in that property 19 years. It didn't matter. The landlord could just come along at any stage, give you 4 weeks notice to leave, and there wasn't a thing you could do about that. In terms of the property the landlord provided to you, it had to meet basic standards, but those standards were minimal. They're called minimum standards for a reason. And effectively, if a landlord provided you with a plug to plug in a heater, it would have met minimum standards. If you had a dispute with the landlord, there really wasn't anywhere for you to go. As I said, there are very few pieces of legislation, and any that were there, you couldn't really go to court for them because of the costs involved in doing that, it really wouldn't have been worth your while. So it was pretty much private rent sector, it was take it or leave it approach. And thankfully, with the Residential Tenancies Act, that's vastly improved. It's not ideal. It's not by any stretch of the imagination, it's not the finished article, but it's certainly much more improved than what existed previously. And that was in place pretty much with little adjustment up to 2015. And in 2015, we, I suppose, started seeing a significant increase in rents. Some of you probably recall it as well, but people were presenting with rent increases maybe 20, 30, 40%. And again, there was very little that they could do if it was all done properly. So there were some amendments brought in to try and tackle the spiraling rent increases. Unfortunately, they weren't that successful. The market was just spiraling ahead, and they didn't have the impact desired. So then in 2016, we had further amendments to the Residential Tenancies Act, and this brought in the rent pressure zones, or the 4% limit on rent increases that now applies to the vast majority of the country. But at the time, it was specifically Dublin and Cork that it was introduced for. And that's taken a bit of time to have an impact, that rents are still increasing, as we'll see later, but certainly the rate of increase has significantly decreased. And thankfully, for the majority of people, they're no longer facing those very significant and unaffordable rent increases. After a couple of years, what we started to see then was an increase in mass evictions. These were often apartment developments where people en masse were being given notice. And the reason why they were being given notice is that either the landlord was selling the properties, or the landlord was purporting to carry out renovations or refurbishments to those properties. And the reason why that ground was being used is that it was mistakenly felt that they could do this, get the tenants out, do some work to the property, but then re-rent it at a much higher rent outside of the RPZ rules. But that wasn't the case. There were very strict criteria in terms of being able to be exempt from the rent pressure zone rules. So that had to be addressed, and that was addressed in 2019, where the rules in relation to ending of tenancies for renovations and refurbishments was tightened up. And since then, thankfully, at that time, we would have seen quite a lot of tenancies being ended on that ground. But since the more restrictive measures have been introduced, it would be very rare now that we see tenancies being ended on those grounds. And also in 2019, the RTB were given additional powers as well. Up until then, the RTB did offer a dispute resolution service, but that really meant that if you were an individual and had a problem, you had to take a case to the RTB. So it was a case, go to the RTB, they make a decision, move on. That could mean, for example, 10 different tenants could have been dealing with a landlord, and all 10 having their deposits retained, or all 10 being given, invalid rent increases, etc. But nothing really could be done with that. But since 2019, the RTB now have additional powers. They have an investigation and sanctions unit, and they can look at very specific areas, the likes of the registration scheme, the rent increases, and the notices. And they can, independently of the dispute mechanism, they can investigate and take further action against landlords. So that's, I suppose, a welcome addition as well. And then we had this time last year, we had COVID, and at the end of March last year, we had an initial moratorium period, and that lasted until the beginning of August, and that was effectively a blanket ban on evictions and also rent increases to try and, I suppose, prevent the movement of people during COVID-19 restrictions. That ended beginning of August, and then we had the additional measures for tenants whose tenancy was at risk because they were impacted by COVID-19. So additional protections were introduced from August for those people to protect their tenancies, and that was up to the 10th of January of this year for tenants who were deemed to be relevant persons. We then had another moratorium in October that was brought in, and that lasted from towards the end of October until the beginning of December, and that then was lifted. Now, the October amendments were different to the previous moratorium in March because that was a blanket ban. The October amendments still allowed notices to be given. They just couldn't be affected during the moratorium period. In some exceptional cases, tenancies could still be ended, even though there was a moratorium. But the October amendments also tied the moratoriums to the travel restrictions. So where the Minister for Health introduced a level 5 national level 5 restriction on movement of 5k or more, the moratorium would automatically kick in. And we're currently in that moratorium at the moment. And I suppose the latest indications are that's lasting until the 5th of April, and that there are an additional 10 days added on to any notice to give people some time to make alternative arrangements if that's lifted. And then in December, we had additional measures which extended protections for the relevant persons. And again, they're protected until April. And again, there's currently a bill looking at extending that by an additional 3 months. So very, very quickly, we're going to go in and have a look at the main piece of legislation itself, the Residential Tenancies Act, which, as I say, has been in place since 2004. And the Residential Tenancies Act was quite a significant milestone in terms of the rental sector in Ireland. And it introduced statutory obligations for both landlords and tenants. It introduced some form of rent control through the rent review process. The cornerstone of this legislation was the security of tenure measures introduced through the Part 4 and further Part 4 tenancies, and it also specified how a tenancy could be ended and the grounds upon which Part 4 or further Part 4 tenancies could be ended. The registration process, previously that would have been done by the local authorities on an annual basis, but that moved to the RTB and then was based on the tenancies. In the future, that'll probably, while still be with the RTB, it'll probably go back to an annual registration as opposed to a tenancy cycle registration. And the RTB set up a dispute resolution mechanism. So if any landlord or tenant or indeed third party had an issue in relation to the tenancy, they could refer a dispute to the RTB, and it was supposed a more affordable and swifter alternative to normal courts. So they're the key areas covered by the Residential Tenancies Act that apply to rented accommodation in Ireland. So effectively, the legislation will apply unless the Act itself states that it doesn't. So it covers most rental situations, and since 2016, it will cover tenants of approved housing bodies, and then from 2019, student tenancies, purpose-built student accommodation were brought in within the remit of the Residential Tenancies Act. Some of the types of lettings that it doesn't apply to will be where a property is let for a holiday purpose only, or it's a business letting, or it's a property in which the landlord lives, and a person is, for example, renting a room in their home. These situations are known as license arrangements, and the normal landlord and tenant laws do not apply. You're effectively given permission to reside in the home of someone. So that they don't have to, for example, register that letting. They don't have to provide you with a rent book. They don't have to ensure that property meets minimum standards or give you any minimum notice or anything like that. You're effectively given permission to live in their property. So it's quite a tenuous situation. And we actually, we don't know how many people are actually in license situations in Ireland. And it's quite a vulnerable, as the COVID measures have shown, it's actually quite a vulnerable group with little protection. That's something that we would certainly like to see changed in the future, that there is protection extended to people in license arrangements.
Stephen, in relation to that license arrangement, what would Threshold like to see changed in relation to that?
Yeah, it's quite a difficult one because obviously it's someone's home, so you have certain, obviously property rights, so you have to be cautious of that. So I think what you, in a license arrangement, what you'd like to see is that they are registered and that there's some basic guidelines, not to the same level as currently applied to tenants, but there are basic rules in relation to, the deposit, the rent being charged, and then how that arrangement is ended.
Okay.
And then also, but I think probably one of the most important things for licensees is probably having somewhere to go if an issue arises, if they have a dispute, that they have somewhere to go to get that resolved. Currently, in the vast majority of cases, as a licensee, you can't really go anywhere. You may be able to go to the small claims court if your deposit's retained, but you can't go to the RTB, and that's badly needed. So it would, if you wanted, you could almost think of it almost like, like a tenancy light scenario. So it'll have the registration of those arrangements, minimum guidelines for those arrangements, and somewhere to go if a problem arises.
Yeah, I wouldn't have an issue per se with the RTB part of it, and somebody overseeing it, and I certainly wouldn't have an issue with a contract, because I mean I operate that myself and have done for a number of years. Not during COVID. I stopped during COVID, but I think from a person's perspective, it's a very, I mean, to say they're not registered is kind of a misnomer, because you do have to notify revenue that you have it, and you have to fill in the relevant form,
Okay.
Now,
I get it. Okay, so
not, but if you're going to mind yourself, you're going to do it right,
yes,
revenue, whatever. And I would always have taken in students, so it would be very much month to month, but in relation to that, it would be 1 month for either party, unless something very untoward happened, and they broke something quite specific, like did something terrible. But yeah, I have found that others that have been in a similar situation to myself and taken in people as a licensee have not drawn up contracts, and that has left both parties open to quite a good bit of problems, because when something is clearly defined, this is what you can do, this is what you can't do, my rules are fairly lax, no smoking in the house, whatever. But yeah, it has always worked very, very, very well for me, but I think that's because of two reasons. One is I'm probably pretty easy to get along with. So once they kept their room clean and tidy, that was grand, and treated as their home, and the only room in the house they couldn't go into was my own bedroom, that they'd full use of it as their home. And just, I suppose, because they were students too, I was kind of a mammy to them, if you know what I mean, in inverted commas kind of thing. And and the contract was there, and it was clearly defined what was permitted, what wasn't permitted, and when the money was to be paid, etc. And I wouldn't have an issue with it being overseen by the RTB, or that. I wouldn't like a situation occurring where they would have rights of tenancy, where it would go further into that.
No, I don't think that would be possible, because it is a person's home. But I think, unfortunately, not everyone would be as diligent as yourself, I can assure you, in terms of making, even though you can receive up to 14,000 per annum tax free, you still have to declare that during the year returns. Unfortunately, not everyone in that situation does that. It'd be very few actually do that, but yet they're getting a significant tax break that perhaps a landlord of a traditional tenant wouldn't get.
I just want to clarify on that. Do you have to declare it even if you don't have other self-employment income?
Even though it's tax free, you have an obligation to declare that in your end of year tax returns.
I always thought that was only if you had other self-employment income as well.
No, you have to declare it, but it is, you can receive up to 14,000 per annum.
Okay.
That's a requirement. So I think having yeah, certainly been able to regulate and know how many people are in that situation is of huge importance, giving them somewhere to go if there's this dispute, and giving some basic guidelines. Certainly, you could not give them the same level of protection that a tenant would have, but I think having a minimum guideline in a contract or whatever, so the parties going into it all know where they stand and they're all well informed. Like, unfortunately, in many cases it works out very well in situations like yours, but we certainly, there's some horror stories that we've come across where, for example, people have moved in these rental room situations, and whilst they're paying a considerable sum of money to stay there, they're not allowed to, there's certain restrictive rules in terms of where they can access, when they can access it. In one particular case, I know a student, he'd moved into a rental room scenario, and he was in the place probably about a week, and the owner told him that he had to leave the following week for 2 weeks because she was going on holidays.
Right. Yeah.
So we have those extremes. So I think, having some form of registration, having some form of guidance in terms of what people can and can't do in those situations, and then having somewhere to go if an issue arises that can't be resolved between them. I think that is badly needed for the licensee sector.
And is there anything in the train in relation to that, our threshold, like, pushing out? Is there any kind of anyone working on that? I think it would benefit.
We'd consistently, and certainly on our website, and lots of our reports and submissions, they're all put up there, and consistently they would be included in that in terms of the the precarious situation of licensees. So definitely, if you go to the website threshold.ie, you'll be able to access further information on that.
Yeah. Okay, thank you.
So it's very important, the Residential Tenancies Act, it only starts when that tenancy commences. So there's very often a lot of risk involved in access and private rented accommodation. Unfortunately, people are victims to the likes of rent scams where properties are advertised and people pay over money and then discover that either the property doesn't exist or the person themselves isn't actually the landlord of that property. And they're quite difficult situations to follow up on. Also, the private rented accommodation, it is covered by the equality legislation, so a person can't be discriminated against under Equal Status Act, but that doesn't say it doesn't happen. It's quite quite a common occurrence, particularly if someone is dependent on the likes of HAP payment. They have terrible difficulties in accessing accommodation, and whilst it's covered by the legislation, if you want to take that further, it involves putting the claim to the party, and then, depending on the response, putting a claim into the Workplace Relations Commission and then attending the hearing. And certainly what we often find is that people's energies are spent trying to source the accommodation. So unfortunately, a lot of discrimination often goes unreported in that case. And just to highlight as well that in relation to private rented accommodation, that a landlord doesn't have to give a person a contract, like a 12-month lease or anything like that. It's entirely optional. Having a contract does not mean you have rights, or not having a contract, it doesn't mean you have no rights. As sometimes people will contact us and they'll be under the impression that because they don't have a lease, they don't have any rights, and that's not the case. They have the statutory protection. The lease is an optional document that can be provided, but what a landlord does have to provide at the very least is a rent book, and in that rent book they record all the details in relation to that tenancy and the rent, deposit, bills, etc. If a landlord fails to provide the rent book, then that can be reported to their local authority. The local authority is responsible for the inspection and enforcement of the rent book regulations. Again, we going back to the earlier points around enforcement and regulation, we have the legislation in place in relation to this. Unfortunately, it's the enforcement of the regulations often leave a lot to be desired, and the rent book regulations will certainly be a case in point in terms of the lack of enforcement where a person hasn't been provided with the rent book. So within 1 month of a tenancy being created, the landlord has an obligation to register that tenancy with the RTB, and that's currently costing €90 to register that tenancy, and that's will cover the life cycle of that tenancy. And it is an offence for a landlord not to register with the RTB. If a landlord fails to register with the RTB, it doesn't mean that a tenant cannot avail of the services of the RTB or that they're not protected by legislation. They are. The landlord obviously won't be able to initiate a case, and they could be liable obviously for late registration or non-registration. And since 2019, the RTB Investigation and Sanctions Unit can take additional action also where a landlord has failed to register a tenancy. In terms of the registration process as we currently have it at the moment, it's the tenancy that gets registered. And obviously, as part of that registration, the landlord has to provide certain details from themselves, but also the tenant. But you can't go along and check and see, that Martinez renting number 1 Stony Batter, Dublin 7, for example. You can go and check and see number 1 Stony Batter is registered, but you won't get any of those details. That's not publicly available information. And again, going back to the pre-tenancy issues where there's a lot of risk. At the moment, if you're looking for accommodation, you have no real way of checking to see, is this property, is this person, the owner of this property, is this person allowed to rent out this property? Does this property meet all the relevant legislative criteria? You're basically going along in hope that, everything is above board, but there's no external place for you to go at the moment to go and check that in advance and ensure that everything is done as it should be done. So that's probably where the registration process could be improved upon. The Residential Tenancies Act sets out basic obligations for both landlords and tenants. These are minimal obligations, and you can have greater obligations on the parties. So I'm not going to go through them all, just to highlight a couple. So one of the key ones from a landlord is that they allow the tenant peaceful and exclusive occupation. So effectively, what that means is once you rent out the property, you may own that property, but it's the tenant's home, and you need to respect the fact that it is their home. So you can't just access that property at will. You need to, if you need access, that is something that needs to be arranged between a landlord and a tenant in advance. And a tenant can say, no, that this time doesn't suit. You can't point blank refuse access all the time. There has to be some kind of accommodation for inspections and repairs. But it's from a landlord's perspective, yes, you own the property, but once it's rented out, it's someone's home, and that needs to be respected. And the landlord has to ensure that property meets basic minimum standards, and we'll run through those in a moment, and also provide details for either themselves or their agent if they have an agent, so the tenant can contact them if any issues arise during that tenancy. Also, more recently, where a person is moving into a tenancy and that tenancy is within a rent pressure zone, a landlord has an obligation to provide them with written information on the rent and how it was set, and how that was set in accordance to the previous rent. Now that unfortunately doesn't happen very often for our tenants, but it's a good way of people finding out that the rent is within the RPZ rules, and if it's not, they can refer that to the RTB Investigation and Sanctions Unit. A landlord also cannot penalise a tenant for trying to enforce their rights. So, for example, if a tenant is referring a matter to the RTB or involved with the Gardaí or any other public authority in relation to the dwelling, then the landlord cannot penalise them for doing so. So that, for example, would most commonly arise, let's say, for example, a tenant is making a complaint in relation to getting a repair carried out, the landlord's not doing that, and it's reported to the local authority, and the local authority come along and inspect the property, and often the tenant is then given notice as a result of that. So a landlord cannot penalise tenants for trying to enforce their rights. And also landlords do have a duty of care. So anyone who's in the property, adjoining that property or otherwise in the area, that the landlord does owe a duty of care to those people to enforce the tenant's obligations. So for example, that most commonly arises in relation to the likes of maybe noise issues or more serious antisocial behaviour issues. So the landlord would have a duty of care to other people to enforce those tenancy obligations. So if there is antisocial behaviour, for example, that is dealt with by the landlord.
Can I just ask a quick question in relation to that point number 2? In the case
Yeah.
of developments, the landlord must pass on any tenant complaints to the management company. Is that all multi-user development?
Yeah, basically, yeah. If you're living in if your property that you're renting, if that's within a multi-unit development and there's the management company involved, and you have an issue that's relevant to communicating with the management company, then as a tenant you inform your landlord of that, and the landlord has an obligation to pass that on to the management company, and also the landlord has an obligation to keep you informed of any response in relation to that matter.
Can I ask a question?
Sure.
Fine. So if somebody is renting from the private and they receive a HAP and they have issues with the landlord who's not doing the repair, can the local authority then pushes the landlord to act on that? And what can they do and how far can they go?
Yeah, as we can jump on now in a moment, but the landlord has obligations under minimum standards, and if they're not carrying out those repairs, it can be reported to the local authority, and the local authority is then responsible for, I suppose, inspecting that property. They will draw up whatever work, if any, is needed, and the time frame within which the landlord has to do that. If the landlord doesn't do it, then the local authority is responsible for the next steps, and that can include issuing what's called an improvement notice and potentially issuing what's called a prohibition notice, which would prevent the landlord from in the future continuing to rent that property or sell that property.
Okay, so it's the local authority's responsibility to deal with it, basically.
Yeah, if it's
okay.
if it's a minimum standards obligation, yeah.
Yeah. Okay.
So we'll run through quickly the tenants obligations, and then we'll get to a slide on the minimum standards. But so some of the tenants obligations, the tenant's key obligation is to pay the rent and any other charges that are due in relation to that tenancy, and unfortunately, from time to time, people do have difficulties in paying the rent, and where that happens, we'd always advise them to immediately contact the landlord to let them know, not to avoid the situation, and just ensure that the rent they're paying is correct, or if they are entitled to supports with the rent, that they're availing of those, and then to try and work out some kind of arrangement with the landlord, be it a repayment plan, for example, to try and protect that tenancy. But just to know that obviously where a person doesn't pay the rent in full when due, that tenancy is at risk, and the landlord can issue warnings, and potentially that tenancy could be ended. Tenant has an obligation not to do anything that prevents the landlord complying with their obligations, allow access at reasonable intervals, and if anything is needed to be done, that they notify the landlord as soon as possible, and not do anything to add to the problem. Not behave in a social manner within the property, and to use it as a residential property only unless otherwise agreed with the landlord. And tenants cannot assign or sublet the tenancy without that landlord's permission.
Stephen,
sure.
I'm sorry, I know you're flying through these. I missed the gap earlier. I wanted to jump in earlier on something else.
Okay, yeah.
If I could, I'll try and be brief. It's just, well, two cases maybe that two that I'm dealing with at the moment, but one would be with someone who the antisocial 7-day notice was given, okay, and it was genuinely from one incident, and it was a new tenant, but we're going through the RTB and it's going to be adjudicated in the next couple of weeks, I'd say. But after the 7-day was stopped, there was a 28-day given. Is that 28-day from, do you know anything about this? Like the landlord or the estate agents on behalf of the landlord gave an extra notice, a 28-day notice. So, like, I'm presuming everything is halted because we're going to go through the RTB, the adjudication. We even have the dispute date for the adjudication. So that's, none of that matters anymore.
Yeah.
For that.
And do you mind me asking, like, without going into too much detail, we can talk later about it, but just roughly, what were the allegations for antisocial behaviour?
It basically, she had the young mother had, where she has one small child, but she had a fight outside her door with the boyfriend's mother. So the two of them had a massive shouting match outside the door. Okay. But she was only a month or a month maybe in the property, and this got straight back, probably from neighbours, got straight back to the landlady who was further down the country, and immediately issued the 7-day notice. Okay, well, if that's what it was, that's not antisocial behaviour. Yeah. So antisocial behaviour is where you're committing an offence which is reasonably likely to affect the well-being of others. Yeah. And for 7 days, that's serious antisocial behaviour. So that would be things like criminal damage, assault, intimidation. So it certainly could be disputed. But it is going. But following on from that 7-day, then there was this other notice. That's the other notice, which looked like a 28-day notice. And I suppose my question is really, even though we're going through the adjudication and we'll see what the result is, the landlady can then enact that probably, and this young mother will have to move out, more than likely. Isn't that the case? Because it's not on antisocial grounds anymore, it's on some other ground or something like that. They're probably just, she's only moved in, so they're probably just using the 28 days in the first 6 months. That's what it's going to be. That's what it's going to be. Does she have a lease agreement or a fixed term contract at the moment? I presume there was a lease. I would check that and see, because if she has a fixed term contract, then she can't just give her notice. For a breach, there would have to be a warning, and then if after a reasonable period of time, if that breach continues or occurs, then they can go ahead and end the tenancy. So it sounds, again, look, we can talk about this if you want later, but it certainly sounds that that they shouldn't be able to end the tenancy on this reason. They won't end the tenancy on that reason. I feel strongly they won't be able to, but I have a feeling the 28-day thing is something that they've already checked out and they know they can, so they'll. Sorry, the second question, very briefly, it was a good bit back about moratoriums. Did you say that, because another case I'm working with, a mother with 5 children going to be evicted on the 1st of May. Our goal here, because she needs a 4-bed and there's no 4 beds going, we're on a strong struggle to kind of keep her in. But the eviction notice, the termination is all legal. It's been checked by threshold and everything. It has to go through. But the moratorium, you said, ends on the 5th of April. Yeah, at the moment. Use the moratorium to keep her in the house while we keep looking. Yeah, well, basically, there's 2 things at play there. We'll look at again in a few minutes, but the current moratorium is due to lift on the 5th. It lasts until the 5th of April, and within all tenancies, there's an additional 10 days provided. So at the moment, as things currently stand in normal circumstances, the earliest that a tenancy can be ended is the 15th of April. Now, that would be where effectively the notice period is up. If there is a period remaining on the notice period outside of the moratorium, then that's been paused, and that'll be added on to the time frame once that moratorium is lifted. Is there any likelihood that there'll be another moratorium, or do you think it's linked into level 5 going down? It's linked into level 5 as things currently stand, based on the October amendments. It's linked to the 5K national restrictions, and bear in mind this is national. So you may recall last year we had the various lockdowns, but we had a couple of localized measures. So in Kildare, for example, you had that, but there was no additional protection afforded to tenants in Kildare during that period of time. I know it was only a couple of weeks, etc., but the moratorium is linked to the level 5 travel restrictions nationally. So at the moment, the mood music is pretty much that
protections will be extended for the relevant persons, so the people who are whose tenancy is at risk due to rent arrears. But it doesn't appear that the general protections, the moratoriums, etc., are being extended.
Yeah, look, thanks.
But that may well change if there's if there's additional political pressure, etc., put on that. But at the moment, that's the way it's looking. But that could change depending on on the daily updates in cases and things like that.
Look, thank you very much.
No problem.
Stephen, you mentioned there a definition of antisocial behaviour. Is that the one of the definitions in one of the housing acts, or
no? This is for the private renters, because we have two I suppose for antisocial behaviour you have two definitions. So for private rental accommodation, you have a definition which is included in the Residential Tenancies Act, and then for local authority housing, you will have the definition that's from the Miscellaneous Provisions Act. So they're two separate definitions for private rented accommodation. There's the three categorizations. The first two would be more serious. So they'd be, as I said, things like criminal damage, threats, intimidation, etc. And then the lesser ground would be where there's ongoing interference with peaceful occupation. So that would be the likes of your perhaps maybe noise, parties, things like that. So the first two are more serious and 7 days can be given. The latter one would be 28 days.
Okay. And what do you know what section of the act that is?
You put me on the spot now. I haven't
Sorry.
seen it in a while.
It's 14.
Yeah, no, I'll send it on. It's 14, I think.
Okay, that's great. Thanks very much.
Not long since I looked at it, but I think it's.
That's fine.
I'll take that out and I can send that on to you, Carl. And the minimum standards, so as you mentioned, these are regulations that apply to private rental accommodation. So you can see outlined here the requirements that all private rental accommodation has to meet. So it has to be structurally sound, that there's a fixed means of heating that the tenant controls, that they have the cooking facilities, washing machine and dryer, and that the installations are good working order, access to the cold water and facilities for hot water, etc. And these are landlord's obligations. These cannot be passed on to a tenant. And where a property doesn't meet those minimum standards, then obviously the process is to bring that to the landlord's attention immediately, and then that the landlord arranges for that issue to be addressed. In the regulations, there isn't any specific time frame for a landlord to carry out certain repairs, but obviously the more urgent, the more serious it is, the sooner that should be done. And if a landlord's refusing to carry out those repairs, or they're delaying in carrying out those repairs, then certainly we can try and advocate on behalf of the tenant. If necessary, they can report that to their local authority, and the local authority has a legal responsibility to inspect the property and to enforce the minimum standards regulations.
Simon, is there any onus on the landlord to give access to the meter reading, say of the electricity or the gas? Or if a landlord decides we're going to tell you how much the electricity is per week or the gas is per week, or per month or by quarterly, whatever, has the tenant any right to access that independently?
The meter, it depends really on who's the account holder. If you're the account holder, you certainly do. But if the account is in another person's name, then it's a little bit more difficult. But certainly, in these situations where arise, you should, as a tenant, in the rent book or the lease, if you're provided with one, it should outline the rent and all other charges for which you're liable. So that would be the likes of your utilities, etc. And if you're not being provided with that information, you certainly should be seeking that seeking evidence of it before making any payments to ensure you're actually paying for what you're using. But if the account is in a different person's name, then it's very difficult for you to get access to the actual meter.
Okay.
Stephen, I wonder, before we go on, should we take a little break maybe for a few minutes, because I know we've been going for about an hour and a half. So is that okay, Stephen?
Yeah, I'm happy enough with that. Yeah.
Is that okay with everyone?
Yeah, it's very interesting though. So it's
Yeah,
brilliant.
time is
Yeah,
flying.
yeah,
Time is-
no, it is. Yeah,
It
it's
is,
very
yeah.
interesting. Yeah.
Yeah, no, good call, Una. Yeah, how long do you think we should
I don't
take?
know, is 10 minutes okay? And come back at about 12:05. Is that okay,
Okay.
everyone?
Yep.
Sounds
Just
great.
a chance
Trying
to get a
cup of
coffee
tea.
and stretch your legs and
Yeah.
stuff. Okay,
Okay.
should we see you back
Thank you.
then?
No
Bye.
problem. Thank you. Bye bye. Tenancies Act introduced some form of rent control in terms of stipulating when rents could be increased and what period of notice needed to be increased. And in more recent times, there are now specific rules, either if you're living in a designated rent pressure zone area, or if you're outside of an RPZ, there are specific rules in relation to rent reviews. So if you're in an RPZ, your rent can be increased every 12 months, but that's subject to a formula. So effectively it limits the increase to 4% per year, and it has to be done within the formula, and you can access that on the RTB website. If someone's living outside of an RPZ, there's no limit on the percentage of increase, but it can't go above market rent, and your rent will be increased every 24 months. So there's a lot more flexibility outside of an RPZ area. But again, in both RPZs and outside of RPZs, a person can dispute a rent review by referring that to the RTB, and they have 90 days to do that. And the rent pressure zones and the whole area of rent reviews, that is subject to review at the moment. So we'll probably find out later this year as to whether they're going to continue or if they're going to be amended in some shape or form. There are a couple of exceptions to the rent pressure zone rules. So for example, if a property is only being let for the first time, so it hasn't been let either ever, or if it hasn't been let for a period of 2 years prior to a tenancy commencing, then the initial setting of the rent will be exempt from the RPZ rules. However, any subsequent rent review will be within the rules required. Another exception to the RPZ rules will be where a landlord carries out a substantial refurbishment or renovation to the property. And this has been significantly updated since 2019. So it's quite specific as to what constitutes substantial refurbishment or renovation. So it would be where either the landlord is increasing the floor space by at least 25%, or there's a significant increase in the BER rating. So it's going up by at least 7 grades, and it has to meet 3 of the following criteria: where there's been a permanent alteration in the internal layout, it's the property has been adapted for use by a person with a disability, where there's been a permanent increase in the number of rooms, or where there's been a lesser increase in the BER ratings, as you can see there. And it's very important that also any work being carried out on a property to meet minimum standards does not constitute a substantial refurbishment or renovation. That's the landlord meeting their basic statutory requirements. So prior to 2019, we've seen a lot of tenancies being ended on the grounds of refurbishment and renovation, in the mistaken belief often that the work being done would have justified a rent review outside of the RPZ rules, and that wasn't the case. But thankfully, we now have the statutory definition and the more stringent rules in relation to seeking exemptions to the RPZ rules. So we haven't seen as many of these in recent years.
Is there a further description in relation to the alterations for a person with a disability? Could that be just a handrail coming into the house, or does it have to be a substantial?
Yeah, it would have to be. It would have to be.
It doesn't state that in the legislation, but
the legislation itself, it doesn't. It's like obviously the adaptations, but in terms of the guidelines, then there's some further information available on the RTB website that you can access in relation to that. But that it would be things that, like maybe putting in maybe a downstairs bathroom, widening of the doors, maybe chair lifts, things, all those significant measures. And bearing in mind, it has to be 3 of these matters, at least 3 of these. So you couldn't just, as for, to use your example, you couldn't just put in a handrail and then somehow claim an exemption. So it would have to be a permanent. It would have to be a permanent alteration, further adaptations for a person with disability.
I'm thinking really, if you wanted, if I was looking to get around it, which a lot of landlords do.
Yeah.
You put in a handrail, you divided 1 bedroom into 2 bedrooms, you've changed the interior structure, you've increased the number of rooms. So you've done a lot of things. You've probably made more money for yourself by adding the extra bedroom, but making them smaller. So I'm just wondering how much legislation there is to back up these rules, so to speak.
The legislation is there. These are the criteria that have to be meted. So, as I say, the RTB would have some further guidelines in relation to it, but certainly from a tenant's perspective, if you wanted to dispute the exemption, you can dispute that going to the RTB and challenge that.
Okay.
So in terms of the rents, as I said, the RTB have just released their report today. This is the most recent DAFT report in relation to the end of last year. So you can see here, these are the average rents in the Dublin 10 area. And I suppose what's very significant about that as well is just yesterday doing a quick search on the available properties in Dublin 10, and I was looking for a 3-bed property and only 2 showed up. So that points to a serious issue in terms of availability.
Yeah, only 2 in the whole of the
Dublin 10 showed up yesterday, yeah.
Wow.
I did a search. You can see, maybe it doesn't come out there on the screen, but these 2 properties showed up. And I suppose more significantly is the fact that the rent, if let's say I was a household with 3 children, dependent on HAP, then I'd be, my limit normally would be 1,300 per month. They have some flexibility to go a bit higher than that, but it's significantly less than the rents being asked for, as you can see there. So I suppose the cornerstone of the Residential Tenancies Act is that they provide security of tenure, and this is called a Part 4 or further Part 4 tenancy. So in the first 6 months of a tenancy, that tenancy can be ended. No reason has to be given, and the landlord has to give 28 days written notice. But thereafter, if a landlord is seeking to end the tenancy, they must use one of the specified grounds, and the longer a person is in a tenancy, the more notice that they're entitled to. And the whole idea is that you have these rolling tenancies of 6-year periods, and one goes into the next, and so on. So the Residential Tenancies Act sets out what's required for a notice to be valid. So it has to be in writing and signed by the person that's issuing it. If it's ending a Part 4 tenancy or further Part 4 tenancy, it has to state the reason, and there may be additional requirements around, for example, providing statutory declarations. It has to specify the termination date on or before which a tenant can leave, and also that if they wish to dispute that notice, they have 28 days within which to do so by referring it to the RTB. And these are the grounds upon which a Part 4 or further Part 4 tenancy can be ended. So the most common one that we would see, it would be, for example, where a landlord is purporting to sell the property within 9 months of that tenancy being ended, and they must provide a statutory declaration to that effect. Also, where a landlord requires the property back for their own use or family members' use, again, they'd have to provide statutory declarations to that effect. And if the properties become available, there's some checks and balances. So if the property is not sold within the 9 months, the landlord has an obligation to offer that back to the tenant. If the property was taken back because the landlord needed it for their own use or family members' use, and it becomes subsequently available again, then the landlord has an obligation to offer that back to the tenant. And then some of the other grounds where the property is no longer suitable for the tenant's needs, or there's been a change in use, the tenant's in breach, or as we saw, the refurbishments and renovations. So each of those will have their own specific criteria and may have additional requirements, like requiring the statutory declaration.
Could you explain what that is, Simon? Sorry. A statutory declaration.
Yeah, the statutory declaration is basically a form that you would get from the likes of a peace commissioner or a notary public, for example. And it's basically it's a sworn statement in front of the authorized person stating that what you're purporting in this notice is true. And that's a requirement. It's an additional requirement for some of the grounds upon which a notice is being ended. So if a landlord, for example, issued a notice because they were purporting to sell the property and didn't provide a statutory declaration, then that notice would not be true.
Sorry, Stephen, can you tell me, are there any statistics around that where landlords didn't sell the house for in the 9 months and then offered it back to the previous tenant? Are there any statistics?
I don't know. I do know I know the RTB are looking at this at the moment. I don't think there's anything published just yet, but it is an area that they have been doing some research into, and they have been liaising with the likes of the local authorities as well to check with them to try and see what, you know, in terms of the notices being given, how many, for example, did actually sell the property, or how many, you know, properties came back on the market. So I don't have anything at hand, but I do know the RTB are looking into that. So I'd advise that watch their space. We had a meeting with them back in November, and they mentioned that they were doing this work.
Thank you.
And these are the normal notice periods. So you can see that the longer the tenancy, the more notice has to be given. And likewise, where a landlord's ending the tenancy, they have to give the tenant more notice than a tenant would have to give to the landlord. So it goes all the way up from 28 days up to 224 days. And these are the statutory minimum notice periods. It is possible for parties to agree at the time to end the tenancy with a shorter notice period, but you can't come along and insist that the person leaves before their statutory time is up. And in certain situations, the likes of the serious antisocial behaviour that we mentioned, and rent arrears cases and all the breaches, shorter notice periods may be given. And then at the end of the tenancy, I suppose one of the key issues that people face and continue to face is getting back the deposit. So just around that, the deposit unfortunately doesn't have to be returned to the tenant on the day that they're leaving or before they're leaving. And again, there's no stipulation that there has to be, for example, a final inspection carried out, although it is recommended that that takes place. So from a tenant's perspective, to maximise the return of the deposit, it's ensuring that the rent and bills are paid and that the property is cleaned, remove their belongings to the best of their ability. There's no obligation to get a professional cleaner. And that a good piece of advice is always that people take maybe photographs to show the condition of the property that they leave it in, just so that if they do have to take further action, they have a visual aid that they can use. And if necessary, again, we can advocate on their behalf to try and get it back, or go to the RTB. And in terms of deposit retention cases that go to the RTB, in the vast majority of those cases, the tenant is successful in getting back some or all of that deposit. And for a number of years now, we've been lobbying for a deposit protection scheme to be introduced to try and take that deposit out of the landlord and tenant relationship. And that actually what the deposit protection scheme was legislated for a number of years ago. It just hasn't been enacted yet.
Sorry, Stephen, can I just ask, if someone is asked to leave a tenancy because of antisocial behaviour, are they entitled to get their deposit back, or is that?
Providing their rent is paid and the bills are paid and they haven't caused any damage to the property, then yeah, they would be entitled to get it back.
Okay, thank you.
Okay. So the RTB, as said, under the Residential Tenancies Act, they offer a dispute resolution mechanism, and some cases will have a time frame. So, for example, if a person is disputing a notice, then normally you only have 28 days within which to put a case into the RTB, or up to 90 days if you're disputing the rent review. And where a person is referring to dispute to the RTB, I suppose they have two key options. They can either apply for mediation. So mediation will require both parties to agree to it and try and reach a resolution, or they can apply for an adjudication hearing where effectively both parties will put forward their case and an adjudicator will make a decision. And it costs €15 to make an application online to the RTB. And if a person is appealing to the second stage at tribunal, that costs €100. And the RTB are still conducting hearings, as a gentleman mentioned earlier, albeit these are taking place remotely during the COVID-19 restrictions. So these are these are some stats in relation to the disputes that went to the RTB last year. So there were over 5,000 disputes referred to them, and you can see that the majority were referred by tenants, followed by landlords, and then at 3% third parties. So these would have been people that perhaps were impacted by, say, antisocial behaviour or noise issues in relation to tenancies. And the main dispute issues from last year, rent arrears, stroke overholding, followed by the deposit retention that we mentioned, and then also where the landlord was in breach of their obligations.
Sorry, Stephen, can I ask you a question?
Sure.
Just go back a slide or two where the landlord doesn't have to get back to the deposit immediately, which is fair enough. Is there a time limit in which they then will have to hand it because the tenant may need that to pay the deposit on their next
no, unfortunately, under the Residential Tenancies Act, there's no time stipulation, in relation to that. And you're absolutely right that, like, obviously that deposit, it's a significant sum of money, and it's often integral in terms of securing a new place. But under the Residential Tenancies Act, there's no time stipulation. Like, we'd, as a rule of thumb, and it is only that, like, we'd say, look, it shouldn't, at this day and age, it really shouldn't be anything more than 14 days, just to allow enough time for inspections to be carried out or any issues to be addressed, and ensure all the bills. But that's not covered by law.
But can there not be some mechanism to say, when you're leaving, you've been given notice, or you've given notice, that there should be some period leading up to that the landlord should really be able to check the property, and then when they go out, just give 2-3 days, maybe 4 days, to go in, have a second look around and return immediately. So why can't that be done?
Why can't you be in charge and then have all that done? Because it's absolutely, what you're saying is absolutely true.
Yeah.
That makes perfect sense to all of us. But unfortunately, that's not the way it is at the moment. In a lot of cases, it's not an issue. It's just, unfortunately, in the cases where it does arise, it can be problematic. That there isn't any requirement at the moment for final inspections before that tenancy ends, or to do a report or anything like that. That's perfectly optional, but it's a good practice for people to have. The deposit protection scheme being proposed, that will have stipulations in relation to how soon a landlord can make a claim on the deposit, and certainly it can separate out as well if there's a dispute. So let's say there's a dispute over a bill, or there's a dispute over a piece of damage to the property, that the balance can get paid pending then, that disputed amount being dealt with. It certainly would improve matters greatly if it was stipulated that there had to be an inspection and all those things done prior to a person leaving.
Okay, thank you.
Sorry, Stephen. Sorry, my name is Aidan, by the way. Sorry, Stephen. I know you've asked me. I'm a community worker in Cherry Orchard in Ballyfermot. But on this in particular, there's a gap between HAP and threshold and the RTB then as well. Like, for loads of people who are under HAP, and they get that, the deposit gets the retention of the deposit. Mm-hmm. Like, there's someone I'm working with at the moment that, like, in August, the 1st of August, they moved out. We're still in a situation.
Yeah.
And what this meant is this young mother who is pregnant time and has kids in the family, under the current landlord, is freaking out because, of course, the HAP are not going to pay a second deposit.
Yeah. And
then stopped all the monthly payments. And each time the landlord has agreed, I don't want to go down the RTB dispute resolution, he's flapped around every time. That's August, and now this is where we're at, and the amount of stress and to the landlord, obviously, and to the tenant. Yeah, it's just a huge hole that people are falling through, actually.
No, absolutely. And that's look, that case is a perfect example of why a deposit protection scheme is needed. So that deposit is taken out of that landlord tenant relationship, and that it doesn't. Not only, it doesn't have any ongoing impact on the next tenancy, because people need, it's a lot of money these days. If you're looking for a property, you need to turn up at the door with usually, the month's rent and the equivalent in a deposit there ready to go. and that's not reciprocated when you're leaving. But yeah, that's what people need to be able to source new accommodation. So it's a perfect example of why the deposit protection scheme is needed, and certainly it should at this stage. Yeah, if it hasn't already been done, I'd be putting a case into the RTB. And probably, in good faith, they kind of gave the landlord the benefit of the doubt or whatever. But look, as you say, August, there's just no reason for that. So, but look, maybe afterwards, Aidan, if you want, we can talk about it. So just highlight a couple of points. Just that nearly half of the notices last year went to the RTB. They were found to be invalid. Nearly half of the rent reviews that went to the RTB were found to be invalid, and in nearly 3/4 of deposit cases, it was found that deposit should be refunded to the tenant. So it shows that there's a lot of problems out there with invalid notices, invalid rent reviews, and deposits being retained illegally. So I'm just going to skip ahead, if you don't mind. So we just want to look at the COVID responses. Obviously, as we said, we're all in this over a year now, and going back to around this time last year, towards the end of March, the government introduced a number of measures. Basically, primarily it was to provide, I suppose, financial support to anyone whose employment was affected by COVID-19, and we had the introduction of the likes of the pandemic unemployment payment, temporary wage subsidy, etc., but also rent supplement, which effectively had taken a backseat to HAP applications. We saw the rules in relation to getting support through rent supplement relaxed somewhat, although ultimately the take up of support through rent supplement, whilst it increased, it didn't increase that dramatically as probably could have done. And you can see here the level of dependency on those supports for the past year. So it's still significantly high, as you can see there. Whilst it did drop throughout last year, it has been increasing steadily since, and it's still at nearly 475,000 people in receipt of the PUB payment. And then you can also see the COVID illness benefit as well. These are the cumulative figures there. So over 136,000 people have availed of that during that time. So I suppose bringing it up to date, we can see that in total there were over 850,000 people received of the payment, and that's I suppose equates to over 6 billion spent just on the pandemic unemployment payment alone. So a lot of support needed out there. And I suppose in terms of the people impacted by COVID-19, if you think of a lot of the sectors that are most affected, particularly the likes of services, hospitality, etc., in many of those cases, the people working in that sector will have a higher percentage of people who are renting. So they've been impacted as a result of that. And continue to need help with it. Looking at the impact of COVID on the rental market, it's quite strange because it hasn't had a dramatic impact yet. Rents continue to increase. The rate of increase may have slowed down. In some areas it may have dropped, but overall rents are still increasing. There seems to be, in terms of the DAF report, there seems to be a bit of a divide. In Dublin, rents have fallen in most of the areas, and that will vary. But outside of Dublin, rents have increased. Based on the DAF report, we've seen the main impact of COVID has been there's probably been an increase in supply, but that increase in supply, whilst it went up 64%, that increase in supply was coming from a very, very low level. And that increase in supply is probably due to the likes of perhaps students not going to college, staying at home. It might be due to, people returning home, either within Ireland or abroad, and freeing up some property, but it hasn't been dramatic certainly not up until now. And as I said, the RTB released their most recent report today. So again, it's pretty much showing the same as the DAF report, that rents are, they're increasing, albeit slightly, and any increases that are happening are greater outside of Dublin. But it's probably still too early to say, what the long-term impact of COVID-19 is. So I know we're almost there. If you could just bear with me for a few minutes. So this is a chart to confuse you and to try and make your way through all the various bits and pieces that have happened in the past year. So up until March of last year with the main Residential Tenancies Act, then all of a sudden we had the initial moratorium, and that ran from the end of March until the beginning of August. And that was a blanket ban on tenancy terminations and also rent increases during that time, and obviously came as a huge relief to a lot of people in a very uncertain time. And when that measure was lifted, it was lifted at the beginning of August, and then immediately after that, a new piece of legislation was introduced, the Residential Tenancies Act for 2020. And the Residential Tenancies Act that introduced new rules in relation to rent arrears, and also we saw the introduction of new measures to protect tenants whose tenancy was at risk due to COVID-19. And that was in place until the 10th of January of this year. Going back to October then, we had the level 5 restrictions kick in again, and then additional legislation was introduced on 24th of October for the Residential Tenancies Act. So that tied any future moratorium to the health level 5 restrictions. And then following that, we also then had the introduction of the extension of protection to the relevant persons. So that was due to end on the 10th of January, and further extensions were provided from the 11th of January to the 12th of April. And then we're currently in another moratorium period, which is lasting until early April at the moment, although it's likely that will be lifted. So it's been quite a strange year in terms of the rental market. Lots and lots of amendments, lots of protections, and some protections for very specific cohorts of renters. And good luck to anyone who's trying to work out on the validity of a notice at this moment in time, for a tenancy that's been in place for a long period of time between all the various, stops and starts.
Can I just ask, in relation to the relevant persons, are the only people that are defined as relevant persons those who have rent arrears?
It's only if you're a relevant person that you have the additional protections.
Okay, thank you.
There are, in terms of the rules for rent arrears, for anyone who's not a relevant person, the warning period was extended from 14 to 28 days, and then 28 days. But for relevant persons, there are additional protections. So the relevant persons, that will involve the individual submitting a form to the RTB that they are a relevant person, and as a result that their tenancy is at risk. So there's a form that they need to fill in, and that's available on the RTB website, and that'll outline their various details, and they also have to provide a copy to their landlord. So these are the criteria for the relevant person. This is the August amendments, so that they were a tenant in that year from the 9th of March up to the 10th of January of this year, and they're either unable to work due to COVID, or they've been in receipt or currently in receipt of, or otherwise entitled to one of the supports provided. So the likes of the illness benefit, temporary wage subsidy, or any other payment, including rent supplement. So that was the criteria for the relevant persons, and the protections going back to the August amendments, and their tenancy was protected then up until the 10th of January of this year. So under normal circumstances, where a tenancy is being ended for rent arrears, it was 14 days warning. That was increased to 28 days. And a process was introduced whereby if a landlord serving a warning, that's served on the tenant, but also a copy is sent to the RTB Upon receipt of that, the RTB would then contact the tenant and advise them of the various supports out there, and that they could benefit from the support of MABs, and that can be arranged. If that tenancy is in arrears, then it can be ended with 28 days notice. Copy is sent to the RTB, and the RTB will let the person know that they can avail of the dispute resolution mechanism. So that's a new process for rent arrears for all tenants. And then in relation to the referral to MABs, where the person does that, they can go to MABs and get, MABs can provide a statement of information on their circumstances, and that can be brought back to the RTB if there's a dispute. So if a person is disputing a notice, that can be brought back, and that can be taken into consideration in the outcome. We had a meeting, as I mentioned, with the RTB towards the end of November, and at that stage, and it is going back now a couple of months, but at that stage there wasn't really a huge uptake in terms of the protection that was available to relevant persons. There may be a number of reasons for that. It was an additional process. It was a little bit cumbersome. Probably wasn't given much publication. People weren't really aware of what it entailed. But certainly they hadn't come across many cases where people were submitting self-declaration forms or being referred to MABs. So this was to the end of October, but at that stage only 6 referrals were made to MABs. So the very, very, very low take up of that. Just waiting on an update to see if there will be an increase in that, particularly as the application process was running out in January of this year and has subsequently been extended. So where a person submitted the relevant person's form, then basically what that did is it would put a freeze on any rent increases taking place during that tenancy up until the 10th of January. And if notice could be given for relevant persons for the rent arrears, then that notice period would be 90 days rather than 28 days. And that their tenancy could be ended either on the 11th of January or whenever the 90 days expired, whichever one was later. I suppose this slide just gives you an illustration of that process for the relevant persons. So the key thing is that where the relevant person tenancy is protected, was protected until the 10th of January, and rent increases couldn't happen, and where notice could be issued, then they were entitled to 90 days rather than 28 days, but it could not take effect before the 11th of January. So they were that was the key measure in August, and that was in place until January. And what we then had in relation to that, I suppose, was that look, it was welcome, but there seemed to be a very low uptake of it. It was aimed at a very small cohort of the rental sector. It wasn't a blanket measure as would have happened in March. And also, I suppose the benefit of it could be questions, because whilst you could go to MABs and maybe get some help, at the end of the day, if your rent was above, say, the rent caps, then you weren't really going to be able to access any additional supports to be able to sustain that tenancy. So the October amendments that came in, they were based on the level 5 restrictions, and they were in place from the end of October to the beginning of December, and a little bit different to the March moratorium, because it made it very clear that they didn't cover license arrangements. This time around, it did allow rent reviews for most tenants except for relevant persons, and notices could still be given during this moratorium. They just couldn't take effect during the moratorium period. And also it covers landlords and tenants. So even there's some cases that we've come across where a tenant is given notice, but technically speaking, that notice cannot take effect until the measures are lifted. So the tenant, in theory, could be liable for the rent until such time as the measures are lifted and the notice period has expired. I doubt that was the intention of the introduction of the measures, but unfortunately in practice it does cover tenants as well as the landlords in the issuing of notices. But certainly a person under normal circumstances cannot be made to leave during the moratorium period unless it's quite a serious antisocial behaviour, etc. Also, it's worth noting that any protection that's afforded as a result of these measures, it doesn't entitle a person to acquire additional protection. So if you were coming up to getting a Part 4 tenancy, which you'd normally do after 6 months, you won't get that if you're just getting up to the 6 months because of the moratorium. So everything is effectively paused. And also where a notice has been issued or a tenancy has been ended upon the lifting of the moratorium, all tenancies will have an additional 10 days added on to that notice period. So there's like a grace period of 10 days. And that's just a little bit of additional time because the measures could be lifted, you know, they could have been lifted at any stage. So rather than having them lifted and all of a sudden being flooded with people having their tenancies ended, the 10 days was added on to just to try and give people, I suppose, a little bit more time to be able to make alternative arrangements. So the March moratorium was a blanket ban. More recently, we've seen that a number of exceptions have been added in. It's not a blanket ban, so tenancies can still be ended on very specific situations. So these would be, for example, like the antisocial behaviour, or where the tenant's in breach, for example, are using the property other than what was intended, breach of landlord's insurance, or antisocial behaviour. So there are some specific situations where a landlord can still end a tenancy. And the relevant person, so that's just been updated now to take into account the more recent cases. So basically, if a person hadn't already availed of the protections, they can avail of these protections, providing they are in receipt currently, have been in receipt of, or otherwise entitled to one of the COVID-19 supports. So just before Christmas, we had another piece of legislation, Planning and Development and Residential Tenancies Act, or PDRTA, as it rolls off the tongue. And basically that extended protections for relevant persons, and it made provisions for people who had already applied under the August amendments, but they had a tight time frame then within which to meet the criteria. But also going forward for tenants who now come under the relevant persons protections. So now what needs to be done is that not only where a person is making the self-declaration form and providing the landlord with a copy, they also need to notify the RTB in writing that they wish to avail of the support of MABs as well. And then also within 5 days of making a declaration, a person, if they're in this category, they also have to serve notice on the landlord that they wish to, I suppose, meet or consult in relation to coming up with some type of repayment plan. So it's, as you can see, it's getting ever more complicated in terms of the various measures and what's expected of individuals. And these are often individuals in very vulnerable situations. There are also now exceptions to the relevant persons protections. So if you're a landlord and a tenant becoming a relevant person would cause you undue hardship, then you can effectively stop the tenant from being able to claim the protections. And that'll happen if, for example, you're, as a landlord, a relevant person. So you were in receipt of one of the payment supports from the 1st of August to the 12th of last year to the 12th of April. Or, you know, if the rent is your only source or main source of income, and you're going to have difficulties in paying the mortgage, if there is a mortgage, you can declare as a landlord yourself as a relevant person, and therefore the tenant can't be a relevant person. So that's probably one of the key changes in relation to the most recent amendments for relevant persons, is that it does take into account the fact that landlords also are having difficulties, and they may be in a difficult situation, and maybe that may be made worse if you acquired the relevant persons legislation. So there are protections in that. Likewise, if you won't avail of it if, for example, the tenant is in arrears of 5 months or more. So you will lose that. Or as a tenant, if you don't engage with the likes of MABs, or you don't adhere to a repayment plan that's been agreed, then you will lose the protection afforded under the regulations.
Stephen, in relation to if the landlord is a relevant person, does it then just come down to whoever fills out the application form first?
Well, no, you can, a tenant could go ahead maybe and put in the form, but the landlord might then, they might submit it themselves.
And that then,
and then that, yeah.
Yeah.
And then you're really, I suppose at that stage, then you're probably really at a hearing.
Yeah.
You know, to try and untangle it all.
Yeah.
There, I suppose the, if you go onto the RTB website, they have actually quite a, there's a lot of information there in relation to all of this, but they do have one where they kind of have like an 8 or 10 step approach as to how it should pan out. Unfortunately, in life, it doesn't always work out that way, but it does set out very clearly. I might actually myself, if you want, I can go back and dig that out and send it on with the documentation.
Okay, thank you.
But it has, look, you know, there's no doubt that a lot of people were impacted by COVID-19 and continue to be so, and there's a lot of uncertainty out there. And we have had quite a lot of legislative amendments, and they can be quite complex. You know, as we're constantly making these changes on top of it, and that can be quite daunting for people as well, because whilst providing for supports, there are a lot of additional hoops for people to have to jump through now. And you know, if you don't put in the application form, if you don't provide the, you know, the true copy, for example, if you slip up on something, then you could potentially lose the protections that are there. And look, you know, these measures are brought in for quite short timeframes. So most recently, you know, before December, it made an amendment to kick in from the 11th of January until the 12th of April for relevant persons. And you know, 12th of April is going to be upon us very, very shortly, which is why now we're looking at another bill to introduce further measures. And again, it's probably for a very temporary period of time. And no doubt there'll probably be some further tweaks to the process to add further confusion to you know, the protections that are out there. Now, I apologies, we did run over somewhat, and I must commend you all on your enthusiasm in staying. Thank you very much for that. It was, from my perspective, it was very interesting as well, and good discussions to have, and you know, very good to get the contributions from everyone. So I suppose, look, I'm available if anyone has any further questions. I can hang on now for a few minutes, or if people want to get back in touch with me afterwards, feel free to do so. And as I say, I'll send on copies of the presentation, and I'll try and dig out that guide from the RTB and send that on as well.
Thank you. Just and I have to go as well, but I was just wondering, with all the new build to rent schemes that are everywhere, and how does thresholds see the situation, and would there be extra protection, or is it going to be worse? Or just wondering. But again, I have to go myself. But
Yeah.
if you have any information or thoughts on that.
Yeah, there are no doubt there are lots of various schemes and interventions to try and improve the supply of private rented accommodation, and to, I suppose, target renters. So it's accommodation specifically for renters, so that property, you know, like, you're not going to be given notice because it's being sold, or, you know, a family member needs it or anything like that. I think the key issue is always, well, there's a couple of key issues, but the key issue is, number one, the provision of good quality, affordable accommodation for people. Affordability is the issue. And unfortunately, just because something is a little bit cheaper than what's on the open market, it doesn't necessarily mean that it's necessarily affordable. And again, these schemes are looking at providing, say, a block of build to rent type properties or whatever, so you're putting everyone into a specific box and everyone's in the same situation. And I think it would work better having a mix in relation to that. But certainly there are lots of different models. There's, the cost rental, the build to rent. There's so many different types of schemes that are out there. But I suppose the key issue for ourselves is obviously the affordability, providing affordable accommodation for people. Like we mentioned there, the most recent DAF report, haven't had a chance to look at it now, but if you look at the sectors most affected by COVID-19, it's pretty much in the service industries. And if you look at the average rent in Dublin, is above the average take-home pay of someone working in the service industry. So that's a huge issue. That's what needs to be tackled. We saw in the tenant sentiment survey where people were paying more, like I think nearly half were paying more than 30% of their income to meet their housing costs. So that's that's gone beyond affordability, and that's having people struggle. And that's what needs to be tackled: affordable accommodation.
Simon, could I ask you, is RAS a thing of the past now, or is it?
It's still there, but it pretty much is. Yeah, it pretty much is. But there is still that residual number of RAS tenancies that are out there. Again, it was an intervention happened at a particular time, and it definitely, it didn't work. Definitely. And look, many of us are dealing with people that are, paying the consequences for that.
Yeah.
But yeah, any RAS tenancy would be a tenancy that was already in existence that we're coming across. We're certainly not coming across new tenancies, but it's pretty much, it's very much HAP in the main. And then obviously, HAP has some benefits in comparison to rent supplement, but HAP also has many of the difficulties that rent supplement had, notwithstanding the discrimination, the administration of it. I know everything has to be administered, but there can be administration issues, delays with it, etc. And it's just the limits are nowhere near the market rent.
And can you just maybe one more question for you in relation to discrimination? And like, I'm working in the traveller community, and the recent report from RTE shows that the traveller community are discriminated against when it comes to HAP, and people just won't rent to them. There's an extensive piece of research done by them. Is there any are the rules good enough to defend against that discrimination, or are they too weak, or they need to be adjusted in some way?
Well, there's two elements of it. Again, look, we do have the legislation. We have the equal status legislation, and that that is quite powerful. But maybe where it does fall down is that the legislation we have in place would tend to require an individual to take a case. So then if you're discriminated against, as I said, when people are looking for accommodation, most people will, something happens, but they'll brush it to the side because their intentions are to try and find somewhere to live. And then by the time they get somewhere, they don't really, want to go back and revisit that. So a lot of cases that are potentially discriminatory go unaccounted for. You're relying on individuals to take that step, and you'll get so far, and it can be very successful. And I know we've helped clients in terms of the WRC cases, and the WRC will make some very significant findings as well, and you'll often see them reported. And I know, like for example, one case last year where we helped a gentleman, he was in his 80s, and he was there was delays and refusals to sign his HAP form, and anyway went to the WRC, and they awarded him €12,000 and ordered that the agency undertake specific training in relation to it. So they're quite powerful, but that's individual. We need, we need a greater oversight and accountability in that respect to I suppose affect real change.
Thank you.
But until that happens, it's easier said than done. But until that happens, it's a case of helping people, encouraging people to take cases where it merits, so that the more cases that go, the more it gets addressed, the more it gets attention, and you hope that then has an influence in terms of people and how they treat anyone going looking for accommodation.
Good, thank you.
Okay.
Can I just ask, are the slides going to be circulated?
Yeah, I'll send out copies of those slides, and as I said, I did come across a thing in the RTB website I think is quite useful, just in terms of the number of steps with this new relevant persons. It's quite useful just to see that process. So I'll dig that out and I'll send that on. It'll be just after lunch. I'll do that for you.
Great, thank you
very much.
Yeah.
Sorry, Stephen, can I ask you, has there been any anticipation by Threshold, or even indeed any other groups who work in this area, about the impact further down the road? Because obviously sometime we're going to come out of COVID, and I can imagine a major changes, not only in legislation, but the effects of it's going to have. Landlords are obviously going to try and recoup what they may or may not have lost in that period and so forth. So I can say a very busy period of time, a year, 2, maybe 3, 4 years down the road. So I'm just wondering, is there any forward thinking what may need to be put in place to anticipate it?
Yeah, no, it's something that's pretty much on everyone's mind. It's kind of shocking when we look at the immediate impact, given the year that everyone has had, and you look at the DAF report, you look at the RTB report on the rents, and you actually see, well, there hasn't really been that much, impact on the ground. And that's not unique to Ireland. There was a piece done by Mick Byrne in UCD, and looking at the impact of COVID on renters internationally. And I suppose from that report, my takeaway from it would have been that, firstly, it's probably too soon, as you say, to get the real impact of it. But certainly at this early stage, what we can say is that COVID has, I suppose, exacerbated the already existing inequalities, and that's only going to increase further going forward. But certainly ourselves, the RTB, independent researchers like McBurn, etc., everyone is actually looking at they've started looking at COVID-19 and its impact.
Okay. Can I ask you one other thing? Earlier on, you were talking about the moratorium being paused. And if you gave the example of somebody whose 6 months was coming up to, and it had to be paused.
Yeah.
Now, obviously, if you're looking a year and a half down the road, they're still in that accommodation, but they can't go to part 4 because their 6 months haven't come up. So the landlord, who may or may not have been impacted by COVID and needs to make money somehow, decides, well, look, I'm cancelling you within that 6 months, even though they're in it for best part of 2 years. It seems to be very, very unfair. Is there any?
I suppose the think, like, and bear in mind there have been, the moratoriums were in place, then were lifted, then were in place, then were lifted. So, in all likelihood, most people aren't going to be hanging around waiting to acquire the Part 4. That have been in the property last year or whatever. They probably would have acquired it by now. Because the periods where the moratorium was lifted. But it's basically, the thinking behind it, I suppose, is that it was to avoid getting into situations that maybe weren't planned for as a result of the moratorium. So it could have been a case that a landlord perhaps wasn't intending to enter into a Part 4 tenancy, and was maybe preparing. They may have been looking for the property back for own use, for example, or whatever, and that, as a result of the moratorium coming in, that they weren't somehow automatically put into that situation that they probably didn't intend to be entering into anyway.
Okay.
So that's the thinking behind it, just to avoid those types of situations.
But it'd be still tough for that tenant who may be in that position, even a year and a half down the road, and whatever reason the landlord decides not to enter into it. So it has an impact for them, the tenant, I mean.
Yeah, and we don't look. The reality is, you know, and I'm sure many of you probably echoed it. Like this past year has been a very strange year. You know, that there hasn't been certainly the same level of activity as perhaps previously would have been the case. You know, it's almost like a kind of stagnation or wait and see.
Yeah.
But that notwithstanding, as you mentioned, you know, it would be foolish to expect anything other than a significant increase in the likes of notices, etc. You know, once all the measures are lifted.
Well, as they say, the balls are up in the air. See what happens when they all drop.
Yeah.
Okay, thank you.
Thanks, Mark.
Listen, Stephen, that's been absolutely fantastic. We kept you for a lot longer than you initially signed up for, but I really appreciate it.
No, absolute pleasure, and apologies for holding people for longer, but we could look, we could be here till the end of the day, and we still, you know.
Yeah, oh, it was brilliant. Thank you so much. And it's something that D10 and 20 Housing and Homeless Network, I think we probably need to really focus on it, you know, over the next couple of years. I would say have a standing agenda item on it, really, I think.
Yeah,
you know, so.
Thank you very much for the invitation. It was very nice to meet everyone. And as I say, if I'll provide copies, but certainly if anyone has any further follow-up queries in relation to this or in the future, we're here to help.
Thank you.